Hello everybody, welcome to ixamBee. This is Amrita and I'm here before you all again with a video which is going to be very beneficial for you for phase 2 examination. You will get many inputs from the memory based paper that we have in hand for you. But before we start with our discussion, don't forget to subscribe to our YouTube channel for such kind of videos and updates relating to government exams preparation. You can visit our website www.ixamBee.com, call on this number and also email us at hello@ixamBee.com for any queries and any information that you require. Also, before we start with our discussion, let me tell you that SEBI Grade A Legal Officer Examination Phase 1 का जो discussion है हम अभी क्यों कर रहे हैं? We are discussing the memory based paper 2022 with all the solutions. And why are we discussing this? Because this discussion is going to be very helpful for you so that you understand some inputs for Phase 2 preparation. जो लोग qualify हो चुके हैं उनको congratulations, big congratulations, and also now it is time for you to devise a perfect strategy. And जो नहीं हो पाए, better luck for them next time. You can also gain inputs from this memory based paper that we have tried to recreate with all the solutions for all the 50 questions. You can also download this PDF of memory based paper from the description in this video, and also you can go and visit our website for the same. How is this discussion going to be helpful? It will help you understand some few important things like the paper pattern. Paper pattern you will be able to understand किस तरीके से questions पूछे गए थे, कौन से type के questions थे, how much it matches with the syllabus that has been provided by SEBI, what subjects were covered and what were not covered, what was the level of the examination, and what kind of questions now you can expect for Phase 2. ये कुछ बहुत important inputs हैं, key inputs हैं जो आपको इस discussion से मिलेंगे. So इस वीडियो को end तक देखो, सारे 50 questions भी आपको समझ में आएंगे with all the options that we have tried to recreate near about. This is an attempt from ixamBee, and yes, this will help you all. Definitely it will help you all a lot. Let us have a look at the syllabus for Phase 2. Why are we having a look at the syllabus of Phase 2? The reason being that it will help us understand in having a comparative analysis कि actually क्या-क्या subjects थे और क्या-क्या weightages थे और इनमें से कितने questions पूछे गए हैं और किन में से questions आए ही नहीं हैं. Phase 2 के syllabus में कुछ topics हैं जो specifically Phase 2 में add हुए हैं, जैसे कुछ parts है Constitution के जो इस phase में add हुए हैं, Phase 1 में नहीं थे, and कुछ topics trusts, IBC, LLP, taxation, ये सब अभी ऐड हुए हैं. तो ये तो Phase 2 में आपको ध्यान देना ही होगा. बट Phase 1 में भी कुछ सब्जेक्ट्स थे जिनसे क्वेश्चन जो होने के बावजूद जिनसे क्वेश्चन नहीं आया, सो उनका भी आपको खास ध्यान देना होगा. लाइक एडमिन लॉ, ज्यूरिस्प्रूडेंस, टॉर्ट्स, इन एरिया से क्वेश्चंस पूछे नहीं गए थे बिल्कुल भी. इन द मेमोरी बेस्ड पेपर यू कैन have an evidence for it. तो इन सब questions, इन सब topics से भी आप questions expect कर सकते हैं Phase 1 में, Phase 2 में. So according to this you have to phase your preparation now onwards. Before I start with the discussion of all the 50 questions, let me announce an offer for you that is available on the courses for SEBI Grade A Legal, General, IT, Research, Rajbhasha. We have online courses available for Phase 2 with a flat 40% off. Go and enroll now. And also it is available on rest of the courses other than SEBI. All the courses available at ixamBee. Visit our website. You can also call on this number and get details about this offer. Now, let me start with the discussion of the PDF that we have created for memory based paper, previous year papers, memory based paper that has been created for 2022 SEBI Grade A Phase 1 examination. ये PDF आपको मिल जाएगा. This is available easily on our website और आप इस वीडियो के डिस्क्रिप्शन में भी इस वीडियो को डाउनलोड कर सकते हैं. Starting with the very first question. First question, it was a situation based question. As you can see, the sequence is not exactly as it was asked in the examination, but we have tried to create the inputs. We have tried to bring down the questions which will help you all a lot in understanding actually किस तरीके से पेपर आया था examination में. A obtains property from Z by saying that your child is in the hands of my gang and will be put to death unless you send us 1 lakh rupees. So ये क्वेश्चन पूछा गया था IPC से एंड इसको डायरेक्टली पिक किया गया था एक इलस्ट्रेशन से, सेक्शन 390 ऑफ IPC, जो डिस्टिंग्विश करता है रॉबरी और एक्सटॉर्शन को क्लियरली. तो उस इलस्ट्रेशन को डायरेक्टली पिक किया गया था एंड यू हैड टू आंसर दैट विच काइंड ऑफ ऑफेंस हैज बीन कमिटेड एंड द आंसर टू दैट वाज एक्सटॉर्शन, दैट इज बी. अगेन इट वाज एन इजी क्वेश्चन फ्रॉम द क्रिमिनल लॉ सेक्शन, लेकिन इलस्ट्रेशन जिसने अगर नहीं पढ़ा हो या जिसे कॉन्सेप्चुअल क्लैरिटी ना हो वो मे बी कंफ्यूज हो गए हो बिटवीन रॉबरी एंड एक्सटॉर्शन. इलस्ट्रेशन डी वाज डायरेक्टली पिक्ड अप. Next, right to education was covered. Right to education, whether it is a fundamental right, whether it is not, whether it is a constitutional right, ये भी काफी expected question था actually, and the answer to that is there in the 86th Amendment Act 2002. Article 21A was inserted in the Constitution, so the answer is A, fundamental right as per Article 21A is the most correct answer out of this. And this topic was also covered specifically in the live classes at ixamBee. इसके साथ आपको हमारे ixamBee की कवरेज भी समझ में आएगी, कितने सारे क्वेश्चंस ixamBee ने अपने क्लासेस में, नोट्स में, पीडीएफ्स में सक्सेसफुली कवर किए हैं एंड इट वाज वेरी बेनिफिशियल फॉर आवर स्टूडेंट्स. So let us also discuss our coverage along with these questions. This was specifically covered in the live classes, course videos as well. Next, writ of certiorari can be filed before. Again a very easy question relating to the jurisdiction of writ jurisdiction that is provided under Article 32 and 226 of the Constitution. Writ jurisdiction of course lies before the constitutional courts. Within seconds आप ये आंसर कर सकते थे. Next, equal pay for equal work, that is provided under which part of the Constitution? ये भी काफी इजी क्वेश्चन था. विद इन सेकेंड्स अ पर्सन कैन आंसर इट. आर्टिकल 39 ऑफ पार्ट 4 ऑफ द कॉन्स्टिट्यूशन प्रोवाइड्स फॉर द प्रिंसिपल ऑफ इक्वल पे फॉर इक्वल वर्क फॉर बोथ मेन एंड वुमेन. सो द आंसर वाज सी, पार्ट 4. ये भी ixamBee के नोट्स में कवर किया गया था. हमारे पास काफ़ी स्टूडेंट्स पूछते हैं कि डायरेक्टिव प्रिंसिपल्स में से कौन से प्रिंसिपल्स इंपॉर्टेंट है, हाउ टू कवर दीज एरियाज. सो हमने टाइम एंड अगेन उनको कंसाइज फॉर्म में ये सारा कंटेंट प्रोवाइड किया है. दिस इज द स्क्रीनशॉट दैट आई हैव शेयर्ड विद यू ऑल ओवर हियर, विच यू कैन हैव एन एनालिसिस ऑफ. क्लासिफिकेशन ऑफ डायरेक्टिव प्रिंसिपल्स, सोशल एंड इकोनॉमिक कैरेक्टर में आर्टिकल 39 कवर होता है फॉर इक्वल पे and equal work for both men and women. What is the meaning of the term amicus curiae? Amicus curiae ये question पहले भी आ चुका है actually and it is very easy. Friend of court is the actual answer for it. Similar question was asked in the SEBI 2020 paper. That also we have available at our ixamBee website in the memory based paper that we had similarly created for 2020 paper that you can still go and have an access. Same question you will find there. Who shall appoint employees of SAT, Securities Appellate Tribunal? It shall be appointed by the central government. Section 155 of the SEBI Act provides that the central government shall provide the Securities Appellate Tribunal with such officers and employees as that government may think fit. This also is included under the coverage of ixamBee. You can see we have discussed it in the class as well as it is present in the course videos and also it is present in the section test. हम लोगों ने ixamBee में कुछ section tests provide किए थे specifically designed for SEBI and उसमें भी ये question present था. So we have very much matched the questions covered in this memory based paper. SEBI chairman is appointed by, the chairman of SEBI is appointed by, again the answer is central government. This is picked from section 4 of the SEBI Act, management of the board. Chairman and the members shall be appointed by central government. A sessions court requires permission of the High Court to pass. This is also an easy question. Of course, for death penalty, High Court requires Sessions Court requires permission of the High Court. ये CRPC से पूछा गया है. Section 366 of CRPC, sentence of death to be submitted by Court of Session for confirmation. This was also covered. A similar question was discussed in our class and the topic was also discussed in the class. As you can see, the snapshot again is there in front of you. This was discussed in the classes of CRPC that were held, and also it was discussed in our course videos. Certified copy of a document is an evidence. If yes, then which type of evidence is it? Very easy question. It is a type of secondary evidence directly provided under section 63 of the Indian Evidence Act. And so this question is also available in ixamBee section test. That is, definition of secondary evidence has been given under which section, and also secondary evidence does not include. So this similar kind of coverage we have covered in our questions in the section test, in the chapter test, and so on. Next, arrest in cognizable cases can be. Again, a question from CRPC. Arrest in cognizable cases can be done by a police officer. That is provided under section 151 of CRPC, and a police officer can do it in cognizable cases, which is defined under section 2 of CRPC. Cognizable offense, and this related question is also present in our section test, question number 3. Which of the following means odi alteram partem? Principles of natural justice related one question was asked, and odi alteram partem, these are the options, and near about, as we have got inputs from the students that the options were near but quite predictable, one could guess that what was the actual meaning of odi alteram partem, and the answer is A and B. Listening to the other side and right of fair hearing is what is odi alteram partem. It is a very basic concept of principles of natural justice. बाकी भी principles of natural justice के दो principles हैं. The one which is recently evolved, reasoned decisions, that also you have to prepare, and nemo judex in sua causa is also important. Same topic question we have covered in our mock tests also, which you can see over here, the 3 principles of natural justice. Next question, what is a contract as per Indian Contract Act 1872? A very direct question relating to contracts. Section 2H of Indian Contract Act defines it. An agreement which is enforceable by law is of course a contract. You can see the question is very easy and a very basic one. Substitution of old contract with new one. This is doctrine of novation. Section 62 of Contract Act provides for it, and is novation of contract is what is the answer for this. Again, an important topic from Contract Act. Contract made by a person under undue influence is void. Now it is void, it is voidable at the option of party whose consent was obtained, void ab initio, valid subjected to the express agreement of the party, and so on. So the answer to this question is B, that is voidable at the option of the party whose consent was so obtained, because it is relating to the consent that was obtained by undue influence. Section 19A provides for that. That is the power to set aside contract induced by undue influence. And this is what is the explanation. Which section of Contract Act defines proposal? Proposal से related भी question आया था, and according to Indian Contract Act 1872, proposal is defined under section 2A. Again, the very basic concept. Contract से काफी सारे basic questions पूछे गए थे जो contract के basic concept से relate करते हैं. Again, Indian Evidence Act, one more question we had on dumb witness. Dumb witness, can a dumb person be a witness? Yes, of course. Under section 119 of Indian Evidence Act, the concept of dumb witness has been covered, and same topic was again provided by ixamBee in their section test also. You can visit our chapter test also. You can see similar question was there on section 119 of the Indian Evidence Act, and 119 of Indian Evidence Act relates to oral evidence of dumb witness. Confession in front of a police officer when valid. Very important question. Section 25 of Indian Evidence Act. Can a confession in front of police officer be valid? and whether it is weak evidence, whether it is valid only when corroborated with substantial evidence, whether it is valid if it is in the presence of a magistrate, valid if taken in front of an independent witness, and the answer is D, valid if it is taken in presence of a magistrate. This was the correct option to it, directly picked from section 25 of Evidence Act. This is also discussed in the classes of ixamBee. Decree holder is any person in whose favor decree has been passed, interim relief has been granted, and so on. Decree holder, very important definition for CPC from CPC section 2 clause 3, and the answer is A, any person in whose favor a decree has been passed. ये भी live classes में cover किया गया था. You can see the snapshots. ये सारे important terms CPC से pick किए गए हैं. A leasee may remove his property that is attached to the earth. This is from Transfer of Property Act relating to leasee rights. 108 clause H of Transfer of Property Act covers it, that a leasee may, even after determination of the lease, remove his property that he has attached to the earth, but the only proviso is that he should take it before he leaves possession of the property. So the answer to this question is A and B or C, that is at any time after determination of lease and at any time when he is in possession of property, or at any time before he leaves possession of property. So you can see the framing of this question, how it has been made confusing, but it is easy concept. Leasee rights were also marked as important. Leaser rights and liabilities were an important topic for discussion in the live classes at ixamBee. Starting with the next important part, 2 to 3 questions were asked from arbitration also. Part 1 of arbitration. When does an arbitration proceeding actually commence? This question was also there in the previous year paper in 2020, and now it is again there. Section 21 of Arbitration and Conciliation Act provides that arbitration starts when request for dispute to be referred to arbitration is received by respondent, request for dispute to be referred to arbitration is made, dispute is referred to arbitration, parties appear before the tribunal when the first hearing takes place. And the answer is A, when the request for dispute to be referred to arbitration is actually received by respondent. So received by respondent is the correct answer. This was also covered by ixamBee in the classes, and also it was told by the faculty to students that it is a very expected area and a question. Languages, arbitral tribunal, commencement of arbitral proceedings is very important from exam point of view. In which of the following cases can courts intervene in an arbitral proceeding? So when can court intervene actually? Section 34 talks about the application can be made for setting aside an arbitral award, and that is what is covered here in the options, and the answer is C. Then when it is proved that one of the party was under some incapacity, only then court can intervene. Out of all these options, only option which is proper and just is option C, if you go through the question carefully. Recourse against arbitral tribunal, arbitral award, another important topic covered by ixamBee in the classes. Moving ahead with the next part, which of the following is a part of fast track arbitration? This was also asked from arbitration topic only, and the answer is that parties may omit oral hearing. Parties can only conduct oral hearing. There are only 2 arbitrators that are appointed. Procedure is completed in 15 days. Procedure is completed in 3 months. This is directly picked from section 29B of the Arbitration and Conciliation Act, which provides for entire fast track procedure of arbitration. This was also discussed in the class and also in the course videos that has been provided in material of ixamBee. ये classes में बताया गया था कि 29A, 29B से questions आ सकते हैं, and ये important sections हैं. इनमें time limit भी पूछा जा सकता है. Now coming to CRPC, What is the age of a juvenile offender as provided under CRPC? Answer was 16 years. This is also a direct question from section 27 of CRPC. 16 years. So the option A is correct for it. And this similar question was discussed in class also by ixamBee faculty. Coming to Specific Relief Act, a person is dispossessed of an immovable property, then a suit can be filed within. Correct option is 6 months from the dispossession. Section 6, very important section from Specific Relief Act, covers the time limit also, that when can a suit be filed for dispossession from immovable property. That can be filed from 6 months of dispossession. This question also you can find similarly in ixamBee material, section test and chapter test. Specific relief is granted for specific performance, compensation, damages, both A and B, that is specific performance and compensation, and all of the above. This was another interesting question that has come up from Specific Relief Act. ixamBee has also covered this question, you can see here, but the answer to that will be, the answer to this question will be A, that is specific performance, which is the very basic objective of Specific Relief Act, which is to provide any equitable remedy or a relief which needs to be fulfilled. Now coming to the next question, question number 26. Here on we will see majority questions from company law. Company law से almost 16 to 17 questions आए थे, 50 questions में से, and thus majority of portion was from company law. This also you have to keep in mind while you prepare for phase 2 की company law से काफी questions आए थे, but कुछ questions उसमें से काफी direct थे, काफ़ी डायरेक्टली पिक किए गए थे और इजी भी थे. So you can go through all these material for good inputs. What is the minimum age of a director of a company? Of course, the answer is very easy, 21 years. You can refer this explanation under section 196(3)(a) of Companies Act. Even ixamBee material has covered this topic in detail, which is very important. A copy of MOA or AOA can be given to the members on a request, and that can be given in how many days? That can be given within 7 days of request. So this was asked. This is covered under section 17 of Companies Act, that these copies of MOA and AOA can be paid within 7 days and on payment of prescribed fees. Copies of memorandum, section 17 of Companies Act. What is the notice period for annual general meeting? Another expected area from Companies Act. Notice period is covered under section 101, and the answer is A, that is 21 days. Covered under ixamBee material in a tabular format, very easy to understand as well as revise. First meeting of a company, that is held within how many days of its incorporation? It is held within 30 days of its incorporation, covered under section 173 of the Companies Act. Similar question we had in our ixamBee section test also. Question number 29, that's almost similar question was there, that within 30 days the meeting can be held. Now, director identification number, DIN, is allotted to a director of a company by whom? Of course, the answer is again central government. You can see it is directly picked from section 154 of the Act. DIN is a topic covered extensively under ixamBee notes. You can see this is how well explained it is and very easy to understand and retain in mind. Also, we had a question in the section test that was there covering this topic. Next question, in case a company makes a default in transferring shares to the IEPF fund, then such a company shall be liable for a penalty of. This was a question not very direct, but again IEPF fund, transferring of shares, important area from company law as per section 124(7) of the Companies Act. Option C will be correct. 1 lakh rupees if a continuing failure is there. Further penalty of 500 rupees will be there for each day. And this will be subjected to a maximum of 10 lakh rupees. This is also an amendment and it is covered in the amendment notes that have been specifically provided by ixamBee legal course. 32. A company may issue fully paid up bonus shares to its members in any manner whatsoever, and that can be paid out of, option E is correct, that is its free reserves, securities premium account, capital redemption reserve account. All these three are the correct options which are picked directly from section 63 of the Companies Act. Bonus shares, an important topic. Which of the following statements is true about red herring prospectus, another celebrated topic from Companies Act? And red herring prospectus, the correct answer is E, that is all A, B and C are true about red herring prospectus. Section 32 of Companies Act covers this topic. Where a company needs additional capital and keeps the voting rights of shareholders proportionally balanced, then the company, further what the company will do, the company will carry out a further issue of share capital, issue rights shares. It will issue rights shares, that is option A is the correct option. Section 62 of Companies Act covers this area. Next question was from sweat equity shares, and the sweat equity shares cannot be given to public at large. Section 2 clause 88 of the Companies Act defines sweat equity shares, and again a snapshot here I have picked for your reference, which defines sweat equity shares as a very important topic, and an explanation is provided with section number which you may go through. इस वीडियो को आप पॉज करके भी देख सकते हैं या फिर आप वीडियो के साथ जो पीपीटी है, जो पीडीएफ है, उसको डाउनलोड करके भी ये मटेरियल आराम से विजिट कर सकते हैं. Which is the appellate tribunal for hearing the appeals from the orders of the National Company Law Tribunal? And the answer of course is National Company Law Appellate Tribunal, section 410, covered under section 2 clause 4 of the Act. Very easy question, NCLAT. Depositories Act, security law now. Depository Act is applicable to, relating to the applicability of Depositories Act. It is applicable to whole of India. Again, same concept covered in the notes, and this is provided in chapter 1 of the Act only, preliminary part. Who can authenticate the documents that are filed by a company to a registrar? This was an interesting question again. The authenticity of the documents that are filed by a company to the registrar can be provided by whom? And the answer is directors. That is option B. It is responsibility of the authorized signatories or professionals signing the form to ensure that all documents and relevant information that is related to the documents is authentic. 39th question, as per Companies Act 2013, a non-profit organization can get itself registered without the addition of the word to the satisfaction of the central government, and the correct option is C, that is the private limited company. Private limited company is the correct answer. It is also known as Section 8 company. Section 8 of Companies Act covers this in detail. This topic was also covered in the live class at ixamBee, as you can see. Very well covered in flowchart format, very easy to understand and retain in mind also. अगर इस तरीके से आपका coverage होता है तो एग्जाम्स में जब ऐसे questions आते हैं, it gets very easy for the students to answer. A depository requires certificate for commencement of business from. This is also a very easy and important question. Section 3 of Security Law of Depositories Act, covers this particular question, and the answer is relating to certificate of commencement of business, and the answer is A, that is SEBI, that is provided by SEBI. This question is also very similar question, very near question was covered in ixamBee material. As you can see in question 44, we have in the section test, we have it in the chapter test also. Who grants certificate of commencement of business to a depository, covered under section 3 of the Act. 41st question, what are the qualifications of a presiding officer of SAT? and the qualifications are provided under section 15M of the Act, which provides that the correct option is D, A or B or C, that is, he shall be a judge of a high court for at least 7 years, or shall be a judge of Supreme Court, or shall be a Chief Justice of a High Court. Either of the three qualifications can be there, and that is provided under section 15M of the Act for your reference. Similar question was there in our material in the chapter test of ixamBee, which you can refer here. If the articles of the company does not provide for appointment of the first director, then it shall be deemed to be the first. Who shall be deemed to be the first director of a company? This question was a bit confusing for the students, as we got it from the feedback as well. But the correct answer is subscribers to the memorandum. Section 152 of the Companies Act covers it, that appointment of directors. This topic is covered under that, and from that, if you interpret, the correct answer will be subscriber to the memorandum. If subscriber to the memorandum was not there in the option, then the correct option would have been promoters. Many students got confused in these options in this particular question. This was also covered with very good explanation in the live class discussion at ixamBee. Court may compel attendance of any person to whom a summons has been issued for this purpose. Then the maximum fine can be imposed to a witness. This is from CPC, section 32, penalty for default. A maximum fine of not exceeding 5,000 rupees. So a maximum fine of 5,000 rupees can be imposed on a witness if he does not come before the court, even if a summons has been issued. Similar question is present in our section test also, that we had specifically provided for SEBI this year, and this is present as it is in our section test. Every company shall have at least one director who stays in India for a total period of not less than 182 days. This is covered under section 149 of the Companies Act. So you can see how many questions are there from the topic of company law, and a lot of questions have been covered. Majority of the paper is on company law only. 149 of Companies Act provides for the answer directly. When can debentures be converted into shares? Again, section 71, very important topic from company law of debentures, and it is also covered in live class at SEBI legal course at ixamBee. What is the minimum age of appointment as a managing director of a company? Again, age related question, very easy. Minimum age of appointment is 21 years for anybody, MD, whole town director or a manager, that is 21 years only. 47, last 3 questions left for our discussion, and then we are done with this fruitful discussion. As per SEBI Act, the questions which came up before the meeting of the board, then they shall be decided by majority of the members that are present and voting. However, in the event of equality of votes, who shall have a casting vote? This was another interesting question, not very direct, but an interesting question that we had from Companies Act, from SEBI Act. And section 7 clause 3 of SEBI Act covers this. The answer will be either B or C. President will have, or chairman will have, or a person who is presiding the meeting in the absence of the chairman will have this casting vote. Section 7 में ये covered है deposit SEBI Act में. This topic was also covered in our course videos. Restrictive trade practice means कंज्यूमर प्रोटेक्शन एक्ट से अभी तक एक ही क्वेश्चन आया है, टॉर्च से तो कोई क्वेश्चन था नहीं, एज आई टोल्ड यू अर्लियर ऑल्सो. एंड रेस्ट्रिक्टिव ट्रेड प्रैक्टिसेस, ऑल द ऑप्शंस A and B are correct. As you can see in option C, only one word not has been eliminated and the option has overturned. अगर आप ये क्वेश्चन को आराम से पढ़ेंगे तो आपको समझ में आएगा. ये डायरेक्टली कवर किया गया है कंज्यूमर प्रोटेक्शन एक्ट को अगर आप रेफर करोगे, रेस्ट्रिक्टिव ट्रेड प्रैक्टिस का मीनिंग देखोगे, सो डायरेक्टली ये यहाँ से उठाया गया है. एंड इवन दिस वाज देयर इन अ सेबी लीगल 2020 मेमोरी बेस्ड पेपर, क्योंकि ये क्वेश्चन लास्ट टाइम भी पूछा गया था. If a judgment debtor obstructs delivery of possession of property, then the court can order detention of judgment debtor. Court can make an order for detention of JD at the instance of decree holder. Decree holder has to make an application for arrest of JD. A and B, any of the mentioned above modes can be adopted. So the most appropriate answer is court can make an order for detention of JD at the instance of the decree holder. अगर आप सेक्शन 51 देखोगे, पावर ऑफ कोर्ट टू एनफोर्स एग्जीक्यूशन ऑफ सीपीसी, ये हम लोगों ने कोर्स वीडियोस, क्लास, लाइव क्लास, सब जगह सीपीसी से सबसे इंपॉर्टेंट एंड एक्सपेक्टेड क्वेश्चन बोल के डिस्कस किया था, एज यू कैन सी हियर. एंड वहां से ही डायरेक्टली क्वेश्चन पूछा गया है, इट विल बी एट द इंस्टेंस ऑफ डिक्री होल्डर ओनली दैट judgment debtor court can order a detention of judgment debtor. The last question for our discussion: when a contract has been broken, compensation for any loss or damage can be caused to an aggrieved party that shall be given for, and the most appropriate answer over here will be either A or C. That is the loss that naturally arose in the usual course of things from such breach, or the loss which the parties knew when they made the contract to be likely to result from the breach of it. So this is what is covered under section 73, compensation for loss of damage caused by breach of contract, which directly provides that such compensation is not to be given for any remote damages causing indirect loss or damage that is sustained by such reason of breach. So we have concluded our discussion for all the 50 questions from SEBI Grade A memory based paper for phase 1. Do watch this video as you have watched this video entirely. This has helped you a lot. I am sure इसके basis पे अभी आप आपकी खुद की एक strategy बना सकते हैं, and phase 2 के लिए without wasting any time you can go and prepare yourself. All the very best. Thank you so much.